Magna Carta, or the Great Charter, was intended to limit the king's power. A group of lords had rebelled against King John for practices such as warring against, dispossessing, and exiling his opponents without legal process. In 1215, the lords cornered King John at Runnymede and forced him to sign a document containing 61 articles. Later English kings reissued Magna Carta whenever they got into trouble. The 14th century was again a time of great conflict between the crown and the nobility. Parliament enacted a series of statutes that became a celebrated foundation of English law. These statutes referred to Magna Carta and confirmed that a trial observing lawful procedures should take place before judgment. Several of these 14th century statutes used a phrase that became deeply associated with Magna Carta and eventually with the U.S. Constitution: due process of law. To early Americans, Magna Carta embodied the idea of a government constrained by law. They saw the Great Charter as the oldest written document of the fundamental laws of England. Americans viewed these fundamental laws as their inheritance, which no king or parliament could take away. Not only was Magna Carta a powerful symbol of limited government, but Americans saw in it and insisted on specific rights. The right Americans most often invoked in connection with the Great Charter was the right to trial by jury. Americans believed this right to be enshrined in Article 29. No free man shall be taken and imprisoned or disseised of any free tenement, or of his liberties or free customs, or outlawed or exiled, or in any other way destroyed. Nor will we go upon him nor send upon him, except by the lawful judgment of his peers, or by the law of the land. By this language, the barons at Runnymede certainly did not intend to enshrine common law trial by jury. In criminal cases in 1215, jury trial did not exist, and in civil cases, jury trial had only limited use. In Article 29 of Magna Carta, the phrase judgment of his peers, per judicium parium, meant that no one could be tried by his inferiors. The barons, therefore, thought they should be tried by each other, a concept that survived in the trial of peers in the House of Lords. But Americans did link Magna Carta with jury trial. They were following a line of thought that had begun in England in the late Tudor period, with antiquarians interested in tracing the ancient constitution of England. Many of these antiquarians thought that jury trials and other English institutions began with the Anglo-Saxons. In their view, Magna Carta confirmed these ancient rights. Edward Coke and others in the 17th century celebrated this link between Magna Carta and jury trial. This was part of an effort to limit royal power. Coke extensively discussed Article 29 of Magna Carta in his Second Institutes, a source well known to Americans at the time of the founding. Americans of the colonial and revolutionary era exalted the jury as a means of furthering self-governance and nullifying despised British laws. In their enthusiasm for the jury, Americans put the translated words of Article 29 of Magna Carta directly into 8 of the new state constitutions. For example, the Maryland Constitution of 1776 states that no free man ought to be taken or imprisoned or disseised of his freehold, liberties, or privileges, or outlawed or exiled, or in any manner destroyed, or deprived of his life, liberty, or property, but by the judgment of his peers, or by the law of the land. The U.S. Constitution does not quote Magna Carta directly, but the Fifth Amendment states that no person shall be deprived of life, liberty, or property without due process of law. This is a reference to the English statutes of the 14th century that confirmed that Magna Carta required due process of law. Americans' views of the jury have changed over time, but the enduring legacy, the ancient inheritance of Magna Carta, is closely connected with the idea of due process of law. As Justice William Johnson of the U.S. Supreme Court put it in a case in 1819, Magna Carta represents the idea that the individual should be secure from the arbitrary exercise of the powers of government.